12 Tables. The law of the 12 Tables Latin, leges Duodecim Tabularum or Duodecimo Tabulae, was the legislation that stood at the foundation of Roman law. The tables consolidated earlier traditions into an enduring set of laws. Displayed in the Forum, the 12 Tables stated the rights and duties of the Roman citizen. Their formulation was the result of considerable agitation by the plebeian class, who had hitherto been excluded from the higher benefits of the Republic. The law had previously been unwritten and exclusively interpreted by upper-class priests, the pontifices. Something of the regard with which later Romans came to view the 12 Tables is captured in the remark of Cicero 106-43 BC, that the 12 Tables seems to me assuredly to surpass the libraries of all the philosophers, both in weight of authority and in plenitude of utility. Cicero scarcely exaggerated. The 12 Tables formed the basis of Roman law for 1,000 years. The 12 Tables are sufficiently comprehensive that their substance has been described as a code, although modern scholars consider this characterization exaggerated. The tables were a sequence of definitions of various private rights and procedures. They generally took for granted such things as the institutions of the family and various rituals for formal transactions. The provisions were often highly specific and diverse. Drafting and development. The 12 Tables of Roman society were said by the Romans to have come about as a result of the long social struggle between patricians and plebeians. After the expulsion of the last king of Rome, Tarquinius Superbus, the Republic was governed by a hierarchy of magistrates. Initially, only patricians were eligible to become magistrates, and this, among other plebeian complaints, was a source of discontent for plebeians. In the context of this unequal status, plebeians would take action to secure concessions for themselves using the threat of secession. They would threaten to leave the city with the consequence that it would grind to a halt, as the plebeians were Rome's labor force. Tradition held that one of the most important concessions won in this class struggle was the establishment of the 12 Tables, establishing basic procedural rights for all Roman citizens in relation to each other. The drafting of the 12 Tables may have been fomented by a desire for self-regulation by the patricians, or for other reasons. Around 450 BC, the first decemvirate board of 10 men were appointed to draw up the first 10 tables. According to Livy, they sent an embassy to Greece to study the legislative system of Athens, known as the Solonian Constitution, but also to find out about the legislation of other Greek cities. Some scholars deny that the Romans imitated the Greeks in this respect, or suggest that they visited only the Greek cities of southern Italy and did not travel all the way to Greece. In 450 BC, the second decemvirate started to work on the last 2 tables. The first decemvirate completed the first 10 codes in 450 BC. Here is how Livy describes their creation. Every citizen should quietly consider each point, then talk it over with his friends, and, finally, bring forward for public discussion any additions or subtractions which seemed desirable. Cf. Liv. Roman 3:34. In 449 BC, the second decemvirate completed the last 2 codes, and after a secessio plebis secession of the plebes, a plebeian protest to force the Senate to consider them, the law of the 12 Tables was formally promulgated. According to Livy AUC 3:57, 10 the 12 Tables were inscribed on bronze Pomponius dig. 1 tit. 2 ss 4 alone says on ivory, and posted publicly, so all Romans could read and know them. Some of the provisions are procedural to ensure fairness among all Romans in the courts, while other established legal terms dictating the legality of capital crimes, intentional homicide, treason, perjury, judicial corruption, and writing slanderous poems. The Romans valued keeping peace in the city, and the 12 Tables were a mechanism of establishing and continuing peace and equality. Laws of the 12 Tables. Tables I and Roman II, procedure for courts and judges, and further enactments on trials. These two tables are concerned with the Roman court proceedings. Table I covers proceedings between the defendant and the plaintiff, with responses to potential situations such as when age or illness prevents the defendant from making appearance, then transportation has to be arranged to assist them. It also deals with the failure of appearance by the defendant. If there is a failure to appear by either party, then after noon the judge must make judgment in favor of the one who is present. Provides a timetable for the trial ends at sunset. Table Roman II sets the amount of financial stake for each party depending on the source of litigation, what to do in case of impairment of the judge, and rules of who must present evidence. Table Roman III Execution of Judgment. The laws the 12 Tables covered were a way to publicly display rights that each citizen had in the public and private sphere. These 12 Tables displayed what was previously understood in Roman society as the unwritten laws. The public display of the copper tablets allowed for a more balanced society between the Roman patricians, who were educated and understood the laws of legal transactions, and the Roman plebeians, who had little education or experience in understanding law. By revealing the unwritten rules of society to the public, the 12 Tables provided a means of safeguard for plebeians, allowing them the opportunity to avoid financial exploitation and added balance to the Roman economy. Featured within the 12 Tables are 5 rules about how to execute judgments in terms of debtors and creditors. These rules show how the ancient Romans maintained peace with financial policy. In his article Development of the Roman Law of Debt Security, Donald E. Phillipson states the 12 Tables were a set of statutes known as the 12 Tables that was passed by an early assembly served as the foundation of the Roman private law. The 12 Tables were enacted in the mid-5th century BC as the result of a conflict among social classes in ancient Rome. pp. 1231–1232. In the book, The 12 Tables, written by an anonymous source due to its origins being collaborated through a series of translations of tablets and ancient references, P.R. Coleman Norton arranged and translated many of the significant features of debt that the 12 Tables enacted into law during the 5th century. The translation of the legal features surrounding debt and derived from the known sources of the 12 Tables are stated as such. 1. Of debt acknowledged and for matters judged in court in or 30 days shall be allowed by law for payment or for satisfaction. 2. After that a lapse of 30 days without payment hand shall be laid on manus infection the debtor. He shall be brought into court Aeneas. 3. Unless he the debtor discharge the debtor, unless someone appear in court in or to guarantee payment for him, he the creditor shall take the debtor with him. He shall bind him either with thong or with fetters, of which the weight shall be not less than 15 pounds, or shall be more if he the creditor choose. 4. If he the debtor chooses, he shall live on his own means. If he lives not on his own means, the creditor, who shall hold him in bonds, shall give him a pound of bread daily. If he the creditor shall so desire, he shall give him more. 5. Unless they the debtors make a compromise, they the debtors shall be held in bonds for 60 days. During those days they shall be brought to the magistrate into the comitia meeting place on 3 successive markets. The 5 mandates of the 12 Tables encompassing debt created a new understanding within social classes in ancient Rome that ensured financial exploitation would be limited within legal business transactions. Table Roman IV, Right of Familial Heads. The fourth table of the 12 tables deals with the specific rights of patriarchs of families. One of the first proclamations of the table Roman IV is that dreadfully deformed children must be quickly euthanized. It also explains that sons are born into inheritance of their family. Babies with physical and mental diseases must be killed by the father himself. If a husband no longer wants to be married to his wife, he can remove her from their household and order her to mind her own affairs. Not all of the codes of Table Roman IV are to the benefit of only the patriarch. If a father attempts to sell his son 3 times, then the son earns his freedom from the father. Women, Tables V, VI, and X. The 12 tables have 3 sections that pertain to women as they concern estates and guardianship, ownership and possession, and religion, which give a basic understanding as to the legal rights of females. Table V, estates and guardianship. Female heirs should remain under guardianship even when they have attained the age of majority, but exception is made for the Vestal virgins. Table VI, ownership and possession, where a woman, who has not been united to a man in marriage, lives with him for an entire year, without interruption of 3 nights, she shall pass into his power as his legal wife. Table X, religion. Women shall not during a funeral lacerate their faces or tear their cheeks with their nails, nor shall they utter loud cries bewailing the dead. One of the aspects highlighted in the 12 tables is a woman's legal status and standing in society. Women were considered to be a form of guardianship similar to that of minors, and sections on ownership and possession give off the impression that women were considered to be akin to a piece of real estate or property due to the use of terms such as ownership and possession. Table Roman VII, land rights and crimes. This table outlines the attitudes towards property. The following are all rules about property. Boundary disputes are settled by third parties. Road widths are 8 feet wide on straight parts and double that on turns. People who live near the road are in charge of maintaining it. However, if a road is not well maintained, then carts and animals can be ridden where the riders want to. Property owners can request removal of trees that have been blown onto their property. Fruit that falls from a tree onto a neighbor's property still belongs to the original tree owner. Table Roman VIII, Torts and Delists, laws of injury. Torts are laws dealing with litigating wrongs that occur between citizens. Such situation is that of physical injury, retaliation for which can range from dealing the perpetrator an injury in kind to monetary compensation to the injured. This table also establishes the legal ramifications for damage dealt to property by animals and damage dealt to crops by people or animals. The penalty for stealing crops is hanging as sacrifice to Ceres. The table also describes several laws dealing with theft. Table Roman IX, public law. This section of the tables makes it illegal for anyone to define what a citizen of Rome is, with the exception of the greatest assembly or maximus comitatus. It also outlaws execution of those who are unconvicted, bribery of judges, and extradition of a citizen to enemy powers. The supplements, tables Roman XI and Roman XII. Table Roman XI, marriage between classes. A person of a certain class shall not partake in marriage with a person of a lower class. Table Roman XII, binding into law. Whatever one or more persons have ordered into law shall be held by the law. Influence and significance. The 12 tables are often cited as the foundation for ancient Roman law. The 12 tables provided an early understanding of some key concepts such as justice, equality, and punishment. Although legal reform occurred soon after the implementation of the 12 tables, these ancient laws provided social protection and civil rights for both the patricians and plebeians. At this time, there was extreme tension between the privileged class and the common people, resulting in the need for some form of social order. While the existing laws had major flaws that were in need of reform, the 12 Tables eased the civil tension and violence between the plebeians and patricians. The 12 Tables also heavily influenced and are referenced in later Roman laws texts, especially the Digest of Justinian I. The influence of the 12 Tables is still evident in the modern day. The 12 Tables play a significant role in the basis of the early American legal system. Political theorists, such as James Madison, have highlighted the importance of the 12 Tables in crafting the United States Bill of Rights. The idea of property was also perpetuated in the 12 Tables, including the different forms of money, land, and slaves. An additional example: the 12 Tables are tied into the notion of jus commune, which translates as common law. Some countries, including South Africa and San Marino, still base their current legal system on aspects of jus commune. In addition, law school students throughout the world are still required to study the 12 Tables as well as other facets of Roman law in order to better understand the current legal system in place. Footnotes. Works cited. Durant, W. 1942. The Story of Civilization. Simon and Schuster. Livy, de Selencourt, A. Ogilvy, R.M., Oakley, S.P. 2002. The Early History of Rome, Books IV of the History of Rome from its Foundations. Penguin Classics. ISBN 0-1444-809-8. Goodwin, Frederick, 1886. The Roman 12 Tables. London, Stevens and Sons.